A few years ago, the United States Supreme Court issued its opinion in McDonald versus City of Chicago. In that case, homeowners won the right to keep their guns for personal self-defense and defense of the home. This was an extension of a ruling a few years earlier in the Heller case, which arose in the District of Columbia. The key new development in McDonald was that the Second Amendment was incorporated and made applicable to the states. Now, this doctrine of incorporation is probably obscure to many Americans. Incorporation is a strange word to use. What I hope to do here is to explain incorporation so that we can make sense of this whole basic idea. Incorporation means nothing more, in this case, than looking to the Bill of Rights and saying that there are some constitutional limits on what Congress and the federal government can do, but these same principles limit what states and state legislatures can do. The McDonald case was holding essentially the Second Amendment applies to state law and limits state policy and state discretion. The story of extending the Bill of Rights to the nation and state law is a long one and a complicated one, and it's one that law professors have been arguing about for years. Part of the story begins with an 1873 case called the Slaughterhouse Cases. That dealt with disgruntled butchers who felt that they were being denied their right to work, their freedom to follow their own business, by a Louisiana law creating a monopoly for butchers and slaughterhouses. The Supreme Court upheld the law and basically said that the Privileges and Immunities Clause of the 14th Amendment meant very little. It only secured and protected already existing federal constitutional rights of the individual. This is pretty inconsistent with what many in Congress had thought, and there was a cry of protest from dissenting opinions. But the law changed. In fact, you might see this story of incorporation as one big end run around the Slaughterhouse Cases. In Oklahoma, we understand the concept of the end run, but it took a century or more to get this done. At first, rights enjoyed by property, corporations, the wealthy, businesses, were the first rights given protection. For example, there's not a sentence in the Constitution which says states are required to give a hearing and just compensation before taking property. But this was the first principle limiting Congress that was extended to state law. What followed was a series of discoveries or inventions, depending upon your point of view. The Constitution was said to protect liberty of contract. There was no reference to that in the text. Next, the First Amendment, speech and religion. You'd think that would be first. It was not. And then, due process rights. And here we have to note an irony. The textual basis for this end run around the Slaughterhouse Cases was the Due Process Clause of the 14th Amendment. The doctrine in law books is referred to as substantive due process. Now, you might think that due process is the right to be heard, the right to notice, the right to a trial, the right to counsel. Not so. The due process that was recognized first by the Supreme Court were these other rights, and only then did it turn to deciding what minimal procedure must be followed by the states before they could enforce the law. It was then we got rulings that extended the Fifth Amendment, the Sixth Amendment, the Fourth Amendment to state police officers and state courts. The right to counsel, the right to a jury trial, the privilege against self-incrimination, protections against unreasonable search and seizure. All this, which we take for granted today, came after some of the early rights incorporated. And only in 2010, in the McDonald case, did the right to own guns in your home become a right that couldn't be limited by state law. What accounts for all of this? Well, judges have told us from time to time, and again in McDonald, The test is what rights are implicit in the concept of ordered liberty. This is, for most of us, an obscure phrase, and it's typical legal jargon. The real question is what's so basic, important, and fundamental we can't imagine freedom and the Republic continuing to exist without these rights? And that has to be answered by looking at history and tradition. We say, and we believe, we can't understand how democracy can work if we don't have the rights of free public debate. We say and believe we don't imagine that there's anything like individual freedom if we cannot be secure and private in our homes. But the court took a long time to give basic answers to all of these questions. And there's still a debate. Law professors mainly, judges have dropped the debate, law professors argue about how faithful this process is to original understanding. And there, what you discover is, of course, ambiguous. Some authors of the 14th Amendment thought the Bill of Rights would be incorporated in the 14th Amendment, but for the most part, there wasn't much discussion of the issue. There was a sense that certain basic problems in the behavior of the southern states would be corrected, but the basic point is there was no legal formula specifically accepted, stated, and codified in the 14th Amendment for the answer to these questions, which leaves the courts to examine history, to examine traditions, to examine the character of our people, to decide what's fundamental, what's essential to free Republican government.